should you trust? Todd, we look forward to hearing your insights on this loaded topic.
As long as that's not me.
Yeah, absolutely. And then for those of you, Leslie has done business with Todd and recommended him, and that's how he got to be our feature speaker here. Swope Investment Properties has worked with your firm. Mike Swope has worked with your firm for decades. Yeah, I like if he's here, I'd like to go on and on decades and decades and decades and decades, but it's not as fun to elbow jab someone when they're not here. So without further ado, Todd Winegar.
Okay, this is my first PowerPoint ever, so I've made it 25 years without having to do one. Stacy said you have to do one, so I'm gonna do one. Okay, we're gonna talk a little bit about estate planning as it relates to real property, maybe some LLC interests, things like that. If you have any questions as we go through this, feel free to ask at any time. Some of the materials, it's pretty straightforward, and typically questions kind of drive a lot of these presentations, so I welcome that as we go through. So the place we'll start, estate planning for the most part really is just property law. How do you hold assets at the time of your death? And then what do your estate planning documents say, and which estate planning documents apply to those assets? And so, okay, so we'll just go through, and if you want to follow on this, you can, and it starts really on page 2. There's 5 or 6 ways we can own property. The first one is just individually owned property. Typically what you think of there is you own your home in your individual name, maybe if you're single. You have a bank account in your name, you've got a, whatever it is, it's in your name individually. When you die, typically what's going to happen then is your will control how that asset gets distributed, whether that's to your kids or whoever it is. The will is going to control that. If you don't have a will, the state of Idaho has a will for you. It's called the Intestate Act. That's going to determine where your stuff goes. So if you've got individually owned assets and you don't have a will, you might look up the Intestate Act. It's going to tell you where your assets. Nope. I'm going to tell you, don't rely on the Intestate Act, but it's there just in case. So that's the first way we can own property. Second way is to own property jointly with right of survivorship. This category is a little tricky, but the idea behind it is if, let's say you own real estate with 4 individuals and the deed says it's owned by all 4 of you with a right of survivorship, when one owner dies, under the law, it's to pass to the other 3 surviving owners. This gets a little tricky in that title companies don't like right of survivorship properties. And a lot of times, even though a deed is held that way, where it should automatically go to the other joint owners, in most cases, a probate will be required in order to have a deed transferring your estate's interest in that property over to the other joint owners. Where joint ownership with right of survivorship works better is like bank accounts and things like that. That you've set up that contractually with that financial institution, so those assets automatically pass to the surviving owner or owners, whoever they may be. With real estate, I would not rely on this in the state of Idaho. A lot of other states, it works fine. Here, it's just a little tricky. I don't know how many times I've come up against issues with right of survivorship property. A lot of people they'll have their deed structured this way to avoid probate. Just know about 90% of the time, title company's probably going to still require probate to ensure that title, going forward with those surviving owners. So not the best option, but you can do it. Property owned jointly without a right of survivorship. So if you've got a piece of real estate, you've got 2 or more names on it, one of the individuals dies, their will control where their 3rd or 4th or half goes. And it's almost just like individually owned property, but you happen to own a building with others. So, okay. Even if you own property as husband and wife in Idaho, if that's all your deed says, your will's still going to control where your half of that property goes, assuming it's community property. Okay, there is one exception to that. We'll get to that in a second. Beneficiary designation property. Yeah, go ahead.
I love interrupting first, so that way other people do.
Okay.
When we're talking about joint ownership, you're talking about if Leslie and I buy a property together. So that's the joint ownership. So we're not already to LLCs. If we put it in LLC, we'll get there later.
Right, yeah, we'll
Okay.
get there. Yeah.
But so if we own a property together and
It's in an LLC.
if there's not a TIC, a tenants in common agreement.
Yeah,
Then we're going through probate.
even if there's a tick, you're going through probate.
Okay, so we're going through. probate.
Yeah, because all the tick does, really, it controls, so the tenants in common agreement controls your rights and your obligations associated with the property, right? And so when you die, there may be restrictions on transfer in the tenants in common agreement, but you still own that interest individually. If that makes sense.
Mhm.
So, I mean, we can skip forward. So let's say you own a piece of property in an LLC. You own your LLC interest individually. So technically, you may be a partnership in that LLC, right? So let's say it's you and Leslie, you own 50% of this LLC. When you die, the question is, okay, what controls the distribution of your LLC interest? You're gonna have an operating agreement for your LLC, right? That may have some restrictions on transfer, may give you, if Leslie dies first, not that that was gonna happen, but if she dies first, you may have rights to buy her half or what have you in her estate subject to that. So typically, it's still gonna require a probate if you've got it in an LLC. There is one exception to that. You can hold an LLC interest this way, beneficially owned. And so some attorneys will do this and some don't, but if you treat your LLC interest as a security and the members of the LLC put in place a beneficiary designation policy, you can hold your interest to where it's subject to that beneficiary designation policy. So it's kind of like life insurance, or like a bank account that's held with a TOD or a POD where it automatically contractually goes to who you've named as the beneficiary. You can do that with an LLC. I don't typically do it unless it's just a husband and wife, for a bunch of reasons. But if it's the only probate asset you have that would require a probate, and we'll get to probate and how that works, you can do that. And if it's just 2 members, sometimes it works. But if you're gonna have 4, 5, 6, 7 members of an LLC, I don't think I'd do that beneficiary designation policy.
If the LLC is owned by an individual, but that individual is owned by a trust.
Yeah.
Do you still have the probate? issue?
No, so, yeah, so we've taken an extra layer. So we've already beat this, haven't we? Okay. Okay,
If
so
it's
trust.
trusted, I'm sorry.
No, perfect. No, it's perfect. Thank you. I almost forgot where we were going. So you can hold, so let's go back to the example before, you got your LLC interest, you own it in your name, you die, your will's for the most part going to control where that goes. If you have a trust-based plan as opposed to a will-based plan, what you'll do and what your attorney will have you do is transfer your interest in the LLC from your name individually to you as trustee of your trust. So now the real estate isn't owned in the trust, but your LLC interest is in your trust. And that's the assets that's subject to your will. You don't own the real estate, you own an interest in the LLC, right? So that's kind of how you get around a probate. Probably the more efficient way to get around a probate, if you have LLC interest, is to use a trust as your primary estate plan, as opposed to a will. That's what this one was meant to address, or trust. So we'll get to trusts here in a bit and kind of go through how those work and whether that's a better option for you or a will is a better option. And this is that one exception to the right of survivorship property. And some of you, I'm sure, have seen this. The law was enacted, I think, in 07, 08. And when it first got enacted, the title companies in town were helping married couples hold property as husband and wife, as community property with right of survivorship. And the upside to holding it in that way is when the first spouse dies, that property automatically passes to the surviving spouse. The deceased spouse's interest goes to the surviving spouse. All we have to do to effectuate that is to record a death certificate with the county recorder, the surviving spouse that owns the property. And in a lot of cases, your house, for most married couples, may be the only probate asset you have. A lot of you, that may not be the case. If you've got LLC interest and things like that, you've got other probate assets. But for a lot of couples, that's it. The title companies quit doing that about 6 months after, because they realized, well, maybe we're practicing law and we're taking a position that this is community property and all this stuff. So they quit doing it. So very few deeds, unless you've had an attorney prepare it, are set up this way. I would say 99% of the deeds I see that are held by husband and wife just say husband and wife. And if that's all it says, that property does not pass the survivor of you by operation of law or automatically. It'll go through your estate and be subject to your will. So, I don't know why Idaho's that way. It's terrible. It's the only state I know of that. We do a lot of probates for couples when the first spouse dies. I practice in Oregon as well. We never do probates over there when the first spouse dies. So that's kind of the different ways you can hold property. This, I'll just throw in real quick, and most of you probably already know this, but you control at your death where your half of any community property goes and 100% of any separate property you own. So if you're single, everything you own is separate property. If you're married, technically what you came into the marriage with was your separate property. If you kept it separate, what you acquired during the marriage is community property, meaning each of you own a 1/2 interest in it. One exception to that is if you inherit assets while you're married, those inherited assets are separate property. So unless you go commingling it, and I mean, one example of that would be if you inherited assets from a parent and you and your spouse then buy a property in McCall or wherever, and you put both your names on it as husband and wife, it may no longer be separate property. There's a transmutation that can take place. So if you want to keep separate, just keep your name on it. Don't put your spouse's name on it. But good luck with that. Yeah. It's like a 35-year rule for my clients. If you've been married 30 years and you inherit assets, they're your assets, not the collective. Anyway, I don't know why that one. So we'll talk real quick about wills and trusts, the difference between the two. Everybody kind of knows what a will is. Pretty simple document. You get around the Intestate Act if you have a will. So at least under a will, you're making certain decisions. You're going to decide who the executor of your estate is. So you get to choose that. That can be important, especially if you got a bunch of kids and maybe they don't get along always or what have you. The other thing you can do, of course, is determine how the assets get disposed of at the time of your death, the disposition of your estate. I'm not going to get into it too much more than that. There are things you can do in wills. If you're married, you've got young kids, you can do a will. You can set up a trust inside that will for your kids that gets funded at your death. You pick a certain age at which, if they're over 30 years old, maybe they get their share of your estate outright. Maybe if they're under 30 or what have you, you want it to go into a trust for them and put some parameters on how it can be used. You can do all of that with a will. The downside of the will, in a lot of people's opinion, is the probate process, the time and expense associated with that. I will tell you, and I've been doing this 25 years or 26, whatever it is. The probate process in Idaho is not that cumbersome. Everybody that moves here from California, and I can't think of a single client I've had that didn't already have a trust, because the probate process in California was a nightmare. Getting someone appointed executor, getting in front of a court, I'm sure in front of a judge, takes a bunch of time. Here, if I file a will with the court and it's done right, the court will typically turn around in 3 to 5 business days and appoint someone as executor of your estate. So they're kind of up and running in a pretty short period of time. There are some costs associated with the wills that aren't that fun to pay. The attorney fees, probably the biggest expense you'll have if you do a probate as opposed to a trust. The filing fee though for a probate here is $170, 171 maybe, I can't remember exactly, but it's not ginormous. There aren't extra estate taxes or anything like that have to be paid just because you do a probate. One downside to a probate, I suppose, is everything that gets filed is public record. So if anybody always wanted to know what was in your estate, what you own and what you were worth, they can find out if they want to.
And do they find out where it goes too?
They could probably get a copy of the will. The will gets filed with the court, so if they want to see who's getting what, they can. Most people don't care, but some people care. So if you care about that, the trust is a better option.
How do the probate fees compare to like the cost of like getting a trust established? I mean, obviously it's gonna depend on the overall value of the estate, right?
Right. I tell people it's kind of a wash. So the cost of trust vary depending on the complexity and all that. But I would say typically here in Boise or even Nampa, wherever, you're looking at $2,000 to $5,000 to get a trust put in place, have the attorney help you fund it, get your stuff in it and do all of that. Wills, I would say for a married couple, usually around $1,000. And that comes with there's a bunch of other documents that go with both plans, powers of attorney and various different instruments, but, so you're looking at, I would say typically 2,500 for a trust, $1,000 for a will and all of that. The probate process, typically the attorney fees, I'd say around $3,000. I mean, they can be 10 times that depending on what happens. They can be less than that depending on what happens. For a trust administration, my typical fees are like $500 to $1,000. I'm helping the trustee kind of just convince the bank and everybody else, these are the trustees now, they have the authority to do what they need to do. So it's kind of a wash. You're paid $2,000 or $3,000 now. The probate's gonna cost $2,000 or $3,000. So I don't know.
And what assumptions are you making in terms of the net worth? Because the probate process, is it a percentage of the overall
No.
estate or is it?
Here it doesn't matter at all. Attorneys typically get paid by the hour on probates. If I do a $10 million estate or a $100,000 estate, my hourly fees the same. And a lot of times the fees are about the same. California, I think it is structured where attorneys get paid based on the size of the estates. You don't have that here. Is anybody over in Oregon? Anybody have stuff over there? Okay. There is a sliding scale there that fees. Yeah, the probate, the reason it costs more and there are more fees is because the court oversees the administration of the estate. So the court's telling us what we have to file from start to finish. You've probably seen these notices in the paper. If you've got a claim against this estate, you have 4 months to file a claim. You know, you have to file an inventory of the court and accounting. There's all these things that have to get filed in order to ultimately go from the start of the probate to the end of it and wrap it all up and distribute everything out. And that takes a little bit of time. That 4-month creditor claim period, you have to wait till that's over before we can close the estate. That doesn't mean you can't distribute some assets during the interim, but that's where people kind of look at it and go, I don't want that. I don't want to wait the 4 months. That's forever. It is kind of a pain, but, and there are some downsides to the probate, no doubt. But in some cases, the probate's nice because we do have a judge that's there and people may not be as excited to fight over what's going on if they know they've got to answer to a judge or whoever as to why they're holding things up or whatever it is. So, yeah, yeah, that's probably more than you wanted. But
Once had some rule of thumb put into my head, where that's where it came from.
Okay.
But if it's on the internet, it must be true.
yes,
But I thought it was some asset value, like if
Right.
your stuff equals
exceeds this, then
something
yes.
M,
Right.
then you
Right.
need a trust. Is there
Yeah.
a merit to that?
Yes and no. So when we're just talking about, you've got a pile of assets, and if it's 2 million versus $200,000 worth of assets, not really. Normally what they're talking about is if you want to structure your estate in some way where a trust gets set up at your death to avoid estate tax. That used to be a much bigger deal than it is now. And so when I first started practicing, I think the federal estate tax exemption was like $650,000. Today, it's like $13.62 million. That number, 13.6 or thereabouts. It's in my stuff, but that number is going to get cut in half if nothing changes. The tax laws that Trump put in place 4 or 5 years ago are going to sunset on January 1, 2026. And so let's say it jumps to 14 million by then. You wake up January 1, 2026, you have a $7 million exemption. For a married couple, it's effectively double that without doing a lot of planning. But I guess to answer your question, when it was $650,000 and you had an estate of $1 or $2 million, what we used to do is take the first spouse that dies half effectively and put it in a trust that the survivor could access the assets to kind of maintain the standard of living they had. But when the survivor died, whatever we put over here wasn't included in their estates. We're using both their exemptions and doing all of that. That's typically what they're talking about. That's not as important now unless you do have a sizable estate. So if you got an estate in excess of $7-8 million, you might still be looking at something like that. Although we can do that with a will too. The trust makes it a little easier.
The trust avoid probate.
Yeah, if you do it right. If you do it right. So, yeah, let's talk about trust. Okay. The way the trust work and why the trust works may not make a whole lot of sense. In explaining it, it's just how it is. I don't know why it's this way, but you set up this trust and there's 3 parties to this trust. You're the trustor, you're putting your stuff in it. You'll also, in all likelihood, be the trustee of this trust, meaning the person who manages it all. and you're the beneficiary, meaning the person who the trust assets benefit. You get all the income from it or what have you. And what I'm talking about here for the most part are revocable trusts. We can talk about irrevocable trusts in a second. These revocable trusts, they don't have a tax ID number. From the IRS's standpoint, it's really as if they don't exist. It's really just property law. And so what this trust says is, hey, during my lifetime, these assets that are in the trust are there to take care of me. When I die, this is who they go to. In order for the trust to help avoid probate, you got to put your stuff in it. And the best example I can give is your house. You know, we talked about if the house is in your joint names as husband and wife, or if it's in your individual name, it'll require probate. What you're gonna do is you'll deed the house from you individually or you and your spouse over to this trust. If it's in the trust when you die, for some crazy reason, we don't have to go to a court to have somebody appointed executor of your estate. You've named who you want the successor trustee to be inside that trust. All they have to do, in most cases, is sign a piece of paper saying, I accept the appointment. So when clients come in to see me after someone's passed, and they're the successor trustee, there's 2 or 3 documents I put together, they sign them, they're off and running. So we're not having you go to the court doesn't have to make the appointment. The other big difference between a will and a trust is a will doesn't become effective, it doesn't mean anything until you file it with the court, the judge looks at it and goes, yeah, you did it right, and then they appoint a person executor. The trust becomes effective as soon as you sign it. That's why they call it a living trust. It's effective while you're living. So.
And if you have a will in the trust, then what? If you go to probate.
If you have a will in the trust, well, you can have a will that has a trust built into it. Those types of trusts, the way I look at those is we got to do a probate to get the will submitted and whatever. You may have a sub trust set up in that will for like a child that you may not want to receive their 1/2 of the estate all at once or whatever it is, but it still requires a probate. With the trust, I think what you're asking is, okay, is there something like a will inside the trust that says who gets what? Yeah, but it's not called a will, it's just part of the trust. So the trust has dispositive provisions that say this is what happens when I die. So there'll be a section that says this is what happens while I'm alive. If you're the trustee, you're deciding all of that anyway. If you're ever incapacitated while you're alive, whoever you name as the successor trustee in that trust, they'll step in and manage that trust for you.
Your securities need to be in a trust.
Sorry?
Your securities need to be in a.
It depends. And so if you got a run-of-the-mill investment account, typically yes. Although most of them will let you set it up with a TOD or a POD designation or maybe a beneficiary designation. So if you go in and see your financial advisor and you say, hey, I want my 2 kids to get this account without having to deal with my trust or a probate, they can set it up with what they call a transfer on death or a payable on death designation. Right. Where it gets tricky and where people get hung up, and this stuff is a pain, is you really have like 2 or 3 columns of assets. You have your house. Okay, the will is going to control how that gets distributed. You got your IRA or 401k. The beneficiary designations on that are going to decide where that asset goes. Then you have these investment accounts or a bank account. You've done a TOD or a POD. That's going to control where that goes. It can drive you insane. And so a lot of times what the trust does, it kind of allows you just to put everything in it. You don't have to worry about the TODs or the PODs so much. We're not worried about all that. We just know we did the trust right. It's going to help avoid probate if we've got it funded and got our assets in. So like that investment account, you'd go down and see your financial advisor and say, hey, here's the language my attorney gave me. I need to transfer my account to this trust. 15 minutes later, it's in the trust. And you don't have to worry about it. You have to worry about the designations and making sure these designations line up with the devisees under your will, which line up with your, all this other stuff. The one exception to all of that are retirement accounts. You can funnel those through trusts. Typically, we don't want to. There's a bunch of complexities with it. And so the 401ks and the IRAs, typically our clients still just use the beneficiary designation. So that's how the trusts work. That's why I said at the beginning, it's really just property law. How are things titled? If your house is in this trust and you die and you have one of your kids as the successor trustee, they find a buyer for the house, they go down to the title company. The title company is going to ask for a couple documents to verify they are the trustee and this trust is in existence. And that's all they're really going to need. If you do a will, And let's say you've named one of your kids as the executor of your estate, and they find a buyer for a house, and they go to the title company and say, look, I'm the executor on this will. Title company's gonna say, we don't care. Until the court appoints you to that position, you don't have any authority. And so where a lot of people get into trouble is family member dies, they get the will, I'm the executor. They may hire a realtor who doesn't look into it very far. They find a buyer, they get to the title company, they're ready to close. The title company says, hey, we can't do this until you're appointed executor. Then we're running to the court, trying to get somebody appointed as quick as we can, so we don't lose the sale and all that good stuff, so. Yeah. I seem to only have bad stories. These trusts were great, you know, there's, what you don't want to do, and this is the worst thing you can do, is you pay an attorney all this money, set up the trust. That person helps you fund it, get your stuff in it. And then you go out and you buy something that's not in the name of the trust, real estate. It happens all the time. Because once you're done with this, you don't want to think about it again. It's not a ton of fun. But you have to remember to keep that trust funded as you go through life. So if you change banks and you go to a different bank and you had your accounts at this other bank in the name of the trust, make sure that it's at this new bank in the name of the trust. Because if you don't, and you've got 2 or 3 assets that are outside the trust that should have been there, the attorney wins, because then we're doing a probate of your will, which names the trust as the sole devotee of your estate. And we're doing a probate and a trust administration. So it's the worst.
But you just said if you have a POD,
Mm-hmm.
then that's okay for.
Yeah. Mhm. The downside of the PODs, they work fine if all your documents are the same. Let's say, you know, when you die, you have 2 kids, each are gonna get half. The PODs and the will and all that, as long as they're all, it's easier to be consistent with them and it can work. The downside I see to PODs is this, under your will or your trust, you may say, look, I've got 2 children, but if one of them predeceases me, I want their share to go to their kids. And if those kids are under this age, I want it to go into a trust. It's all laid out very cleanly for you. And you sit there with the attorney for days talking through all this stuff. With the POD, you don't always have those options. That contract you have with the financial institution is going to say, okay, it either just goes to their kids or it goes to the survivor or what have you. So you have to make sure all that's consistent. Sometimes that is exhausting, you know, going through all those contracts and making sure they all line up. So I like the trust for the simple fact, if you want to avoid probate, you get your stuff in the trust, you let the trust terms control the distribution of your assets when you die. Everything's kind of in one place.
What about like automobiles?
Yeah, so I usually don't tell clients to put the cars in the trust while they're alive, just because you're always buying new cars. And bank, unless your last name's Simplot, the bank will not loan you money, will not loan a trust money to buy a car or anything like that. And so there's a way to transfer cars typically without a probate at death. I just keep them in your individual name. Unless you have a big car collection, then we look at putting some of them in the trust.
So you have to probate them though?
No, so let's say you came to see me and you've got your car, it's worth $50,000. We put your house in the trust, we put all this stuff in the trust, and you die and the car's not in your name. We can use what we call a small estate affidavit, which we just file at the DMV, and they'll transfer that vehicle to the trust. So it does take an extra step. I mean, if you wanted it to be as efficient as you could possibly make it for the fiduciary of your estate, that trustee, we can put the cars in the trust. But it's just kind of especially if you're younger and you're in your 40s, 50s, that's young. It's just kind of a pain.
Can you continue to add things into the trust?
Yeah.
That's been created?
Yeah, all day long. So you can change the trust however you want. You can amend it. You can change the beneficiaries, you can put assets in, out, do whatever you want. And most financial institutions, title companies, they're familiar with these trusts. You know, when you go to sell your house, it's in the trust. They know what to ask for. They understand how it works. You buy a new house, do it in the trust. They understand how it works. And you can always call your attorney, hey, remind me how I'm supposed to take title in this place, you know, or this account or whatnot. So,
And what was the difference between revocable and irrevocable?
So, okay, so we can get into that a little bit. I know somebody maybe had some questions about a charitable remainder trust. The difference between the two are the irrevocable, you really can't change once you set it up. And it does have a tax ID number and all that. It becomes a taxpayer depending on there are some exceptions. But for the most part, what you're doing with the irrevocable trust is you're moving assets out of your estate for estate tax purposes. So we talked about that exemption that's almost $14 million. If you have a large estate and we want to try to get some of it out of your estate so that you're under that amount, sometimes these irrevocable trusts are a nice way to do that. We can put assets in there that may be worth X amount today, $500,000, and we anticipate to be worth $2 million when you die. We've gotten that $1.5 million of growth out of your estate for estate tax purposes. I do less of these now, just again, because the exemption is so high. We used to do a lot of these when the exemption was $650,000. Now that it's 14 million or soon to be 7 million, if couples double that amount, we just don't see these a lot because you're giving up a fair amount of control over the asset. I know, like for example, a charitable remainder trust. The nice thing about those is you can move more assets to a charity maybe than you otherwise could. The increase in value of it's out of your estate. You can set those up in such a way where the income generated by those properties comes to you still, or to whoever you want to leave it to. And then at your death, the asset then passes to the charity. There are some benefits to those in that if you have an asset that has a really low tax basis, and you know if you sell it, you're gonna have a big capital gains tax if you're not getting 1031 into something else. Once it's in one of those charitable remainder trusts, there's some exceptions to this, but the property could be sold and that capital gains tax probably won't have to be paid at that point. And so it either delays that or gets around it altogether. So sometimes there's some benefits that way. There are some states where there's irrevocable trusts that we use for credit shelter purposes, where you're trying to get around creditors. You're not that you have a bunch of creditor claims lining up today, but if you're scared, hey, if I get in a car wreck and someone gets a big judgment against me or my assets at risk. I think your easiest defense against that in most cases is a good insurance policy. Probably have your properties in LLCs if that makes sense for you. But some clients will take it a step further and set up trusts in like Nevada or Wyoming or Alaska where there's some creditor protection. We don't really have that here. So you're looking at going out of state to get it done, which gets expensive. And I've had clients do it. You know, some of my clients, doctors, those who have larger estates. I don't do much of that. Again, Idaho, we just don't really have great options. Anybody have any other questions about the irrevocable trusts or how those work or?
I got one thing. So is there a process, either will or trust or anything that
Like a black and white
that
answer?
you would,
Yeah.
use to reset the basis?
Oh, no matter what, if it's in a revocable trust or in your name, when you die, there's gonna be a step up. Other than your retirement account. So IRAs, 401ks, no step up. Everything else, and what he's talking about is, let's say during your lifetime, you bought a piece of property, cost you $500,000 and you died, and that's still your tax basis. It probably depreciated, but let's say it's 500 grand. When you die, it's worth $1 million. The new tax basis in that property is going to be $1 million. So if your kids inherit that property and they sell that property for $1 million, they have no capital gain. And so one thing we lose on the irrevocable trust a lot of times is that step up. In your revocable trust, there's going to be that step up, and that's huge. And the step up is whatever the fair market value is as of date of death. That applies to your investment accounts, your stocks, applies to all your real estate, your LLC interest, all of that.
So it will step up within a revocable.
Yeah. Because you still have, the easiest way to look at it
And
is,
that's if the trustor dies.
right. Yeah, I would just look at it as you die, whatever you own, whether you put it in the trust or it's in your name individually, that asset's gonna get a step up.
And you can't die better with 1031.
Well, you can until you die. So yeah, a lot of my clients just 1031, 10 to 31. they do them, and they're planning on dying, you know, their last 1031 will be done before they die. They die, then you get a step up. Even if you 1031 into 100 properties, you know, over time, over and over and over again, you get that step up. So
Until you drop.
yeah, that's the best plan.
Yeah.
Yeah. That's what you want to hear. I think what else I can tell you.
What about in terms of liability protection?
Yeah, so this type of trust gives you no liability protection. From a creditor standpoint, it's as if you own it. It does sometimes make it a little tougher for attorneys coming after you. They got to figure out how a trust works, and some attorneys don't know how that works. So it's a little more work, but I would look at it. It doesn't provide you any protection. The best protection, like I said, probably is put your stuff in LLCs. You know, and I'm sure all of you have had this conversation with your attorney. Do I do one LLC? Do I do an LLC for every single one of my rentals? What do I do? And then have a real good insurance policy in place that's going to cover most exposure you may have.
Neither of these trusts provide liability protection.
Not really. The irrevocable, maybe, if you don't have any credit claims at the time you put the assets in there, technically your interest in that trust may then be limited to that income stream that's coming out, but a creditor can attach that income stream. So, and yeah, if you want to get around it completely, I would set it up out of state. But I'm not telling you to do that, but
Well, it's interesting, there was a case, somebody had it set up in Wyoming, and it was in another state out east, and they said they don't care.
They don't
want
respect
our
it.
rules.
yeah, no, you guys have probably seen this. Do any of you have a Wyoming LLC for your rentals? We've had a lot of clients. We've done a bunch. Actually, my sister-in-law is an attorney in Cheyenne, so we referred over there. But the upside to Wyoming LLCs is if you have an LLC interest and you get sued, let's say somebody gets a judgment against you for $500,000. They're looking at what assets you own to satisfy that $500,000 judgment, right? They look at your LLC interest, they're not that excited about it. In Idaho, what they can do is they can attach basically the income stream that comes to you. It's called the charging order. They can get beyond the charging order and foreclose on your LLC interest. They can convince a judge, we're never going to get paid. They're just dribbling money out of this LLC. They basically shut down distributions or what have you, or it's just bare ground or whatever it is. So technically, under the law, there's a chance your LLC interest could be foreclosed against to satisfy this judgment. In Wyoming, they can't get it. They can only get the charging order. So they can only get the income stream. They're not allowed to foreclose on your LLC interest. That's the difference between Idaho and Wyoming, and that's why some people do the Wyoming LLCs. But you're right. Sorry, I was rambling, but the point you made is correct. Will an Idaho judge honor or respect a Wyoming LLC? I don't know. Depends on the day, I guess. Or these trusts, these irrevocable trusts, they're out of state. Same question. What do you think?
Isn't one of the advantages of the Wyoming trust is your anonymity?
Trust? Yeah, trust, sure. But I'm just thinking about the LLC.
Yeah.
Yeah.
Yeah, but if they don't, if it's owned by a Wyoming trust, the real estate, there's no way they can know who that I own, right?
Well, I think if you had a judgment creditor and you went in, they did a debtor's exam, I think you're supposed to disclose that, but I don't know. It'd be harder if you're less than forthright, yeah.
I just have an agent, I have an Idaho agent
Yeah.
go to the deposition for, right?
There's probably, you can make it difficult. Definitely can make it difficult. Yeah.
So supposing there was a judgment brought against you and they were going after your LLC, is that standardly difficult to do, or is that relatively easy for them to achieve?
It's not that hard for them to do. So there's two steps really, and I don't do much creditor work. I don't file lawsuits, but what I know is, let's say someone sues you, 99% or 95% of these lawsuits get settled before trial. So you know what the amount's gonna be, and your insurance company pays it, and you're done. If though, let's say it goes to trial and the judgment exceeds your insurance coverage that you had, and so there's a judgment against you for $500,000, the creditor then has to take the next step and they go through the court system to try to satisfy the judgment, foreclose on assets, turn over assets, get a writ, whatever it is, garnish your your paychecks, all that good stuff. So there's all those hoops. That's the second step on the hoops they have to jump through. So with an LLC, what they're doing is the first thing they'll request is a charging order to get the income that's coming out. And then if they can convince a court that's just not enough. This guy's playing games with me. All of a sudden they were collecting $50,000 in rent last year. Now they're collecting $5,000. I'm never going to get paid. And they can try to convince a judge to let them foreclose on your LLC interest and basically get the asset. What the LLC really gives you, I think, is some leverage. And you probably know better than I do. But what it does is, let's say there's a judgment for $500,000, and that creditor knows there's about a 20% chance this judge is going to allow a foreclosure. That charging order, it's going to take us forever to get paid. It gives you leverage to say, look, I'll give you $200,000 today to go away on your $500,000 judgment, or whatever it is. I think that from a real world standpoint, that's what it gives you, some leverage. I don't really do that kind of work, but I think that's what it does. Jeez.
Fence between that base.
Yeah, you're not gonna go, okay, here's my LLC, here, go ahead, take the apartments, that's not how it works. It's gonna be work for them. We always tell our clients, getting the judgment in some cases is the easy part. Going out and satisfying that judgment is the hard part. A lot of people are judgment proof, they have enough debt against their house, the first 175,000, I think now, or 170, whatever it is exempt from creditor claims. Your IRAs are exempt from creditor claims, other stuff. You do things like what he's talking about, and you make it hard to find, and people are good at that. So, yeah, it's work to satisfy a judgment. But the LLC makes it harder. Yeah, I've depressed everybody. I think we talked about all these. Again, if you have an LLC and you have a trust, make sure your LLC interest is in the trust. Sometimes these operating agreements will say, well, you can't transfer your interest out of your individual name without everybody's consent and all this stuff. So one thing you'll want to do if you do set up a trust, or your attorney will do it for you, is review your operating agreement to see what restrictions there are. You kind of don't want to go to the trouble of doing all this if either the operating agreement says you can't transfer to a trust, or if it says that, your partners are going to be jerks and not let you do it. So there's that. So yeah, lots of stuff. I know it sounds difficult. The best advice I can give you, I suppose, is go to an attorney that understands how the trusts work and the wills work. I would guess if you went to 50 estate planning attorneys in Boise, 10 would tell you all day long you have to do a trust. Probate's the worst thing in the world. 10 are going to tell you just do a will. These trusts are a waste of time. They never get funded right. And 25 or 30 of them will say, look, this is how they each work, and let you decide. That's the approach you want, because there's not a right or wrong way to do it necessarily. Your attorney needs to know what your goals are, what you want to accomplish. Do you want it to be a private administration? Do you want it to be as easy as possible for that trustee you've named? The other most important decision you're going to make, and I didn't talk about it, has nothing to do with really real estate or anything like that, although that's who you're appointing to those fiduciary positions. There's 2 points in time where somebody's going to step in and act on your behalf. One is if you're ever incapacitated during your lifetime, whether because of an illness or an accident or something like that, you're going to have in place a power of attorney or a trust with a successor trustee that then steps in and manages your assets for you, including your real estate and your LLC interest and all that. So when you're deciding who that person is, it's really important, especially if you've got LLC interest. You want somebody that understands how this stuff works. So your options normally are name a family member or a close friend that you think can do that. or you name a professional fiduciary, whether it's a bank, a trust department, whatever it is. But that's, in some cases, that's more important than how your stuff gets distributed or which tool you use. It's who are you putting in that position. The other point in time when they step in is when you die. And everybody understands that. That makes sense. I'm gone. Somebody else is gonna have to manage the stuff for me. But a lot of times we forget about what happens if I'm alive and I just can't do it anymore. You want to make sure you've got somebody that can think. If you don't have those documents, what happens is the courts get involved and they appoint a guardian for you, a conservator. And you don't always have much say in who that is, especially if you are incapacitated. So doing a good estate plan addresses all of that. So I guess my point is there's a bunch of other peripheral things that are just as important as, you know, avoiding probate or not. How to put title. Yeah.
Okay. So I die. I have a trust. Did you say the kid has to file? Or you did, okay, that's right. They just go on with life and collect the money from the bank and sell the properties because everything's set up.
In the
properly.
trust, yeah, so they're probably not gonna have to go to court for anything really.
Don't have to do nothing. Just
Well,
put the money in.
I can agree with you, or I can tell you how it really works. I mean, the way it really works is a lot of the steps they take, whether it's a will or a trust, are the same. They're gonna make sure your final bills and expenses get paid. They're gonna make sure your final income tax return gets filed and the tax gets paid. They're gonna make sure the house gets listed with a reputable realtor. They're gonna go through all that entails of selling the property and doing all of that. So the steps they're taking are about the same. The biggest difference is with a trust, we're not filing documents with the court along the way. There's a little bit more flexibility. It's private. Again, the person gets appointed almost automatically, not appointed, but they accept the appointment almost automatically. With the probate, we're filing, you know, an inventory with the court as well as providing an inventory to all the heirs or devotees of the estate. At the end of both processes, typically there's going to be an accounting put together. So everybody who's receiving assets from your estate know what you spent to get there and what's in there, what their share is. With the trust, we have a little bit more flexibility, but it's similar to an accounting we'll file with the court. It's just typically over here, you don't need the attorney to really do quite as much. The court's going to tell us this is what the inventory has to include. This is what it needs to look like. And so that's why the attorney fees are a little heavier. But you're doing the same stuff with them.
But if the trustees want to sell the property, all they need is a certificate of death, and they can go to the title company and execute the sale. And if you have two trustees, do they all have to agree?
Usually.
But if they don't agree,
Depends what the trust says. Typically, if you have co-trustees and it's involving real estate, that title company is gonna want both of them to sign that deed. The real estate agency is gonna want both of them to sign the listing agreement, all of that. Trust, I've done lots of trusts, will say, okay, trustees can act independent of the other. Co-trustees can kind of be a pain. It's easier if you have one trustee. But in some cases, it makes sense to have more than one, but in most cases, it's easier to have one. So if they go to the title company, what they're taking are, they don't even need a death certificate, really. They need what we call a certificate of trust and something that shows that they're the trustee. And I typically prepare those that first meeting I have with clients. There's 2 or 3 page documents. I give them to them right then, and they don't have any issues from that point going forward, convincing financial institutions, title companies that they're the trustee and have the authority to get done.
where does a certificate of trust come?
The attorney prepares it. I prepare it. It's a what it is, it's like a 1 or 2 page document that you can use in lieu of providing a whole copy of the trust. There's a statute on point that says third parties, you can rely on the certificate of trust in lieu of reading the entire trust.
That's included in the trust when you originated.
Yeah, if your attorney's doing it right, you'll get a certificate of trust, you'll get all of that.
Yeah.
But when you die and you're no longer the trustee, that new trustee is gonna want a new certificate of trust to show that they're the trustee. And that trust, when you die, then becomes a taxpayer, they have to get a tax ID number, and anyway. It's simple. It's just, I mean, I do all of that for my clients. The hard part is the stuff you think about, cleaning the house out. Dividing up the stuff in the house, your personal property. That's, that's the hard job. The rest of it, all this other stuff, the attorney does it. For the most part. They'll walk whoever it is, whoever the trustee is, they're walking. I send out like a 5-page, I meet with the new trustee. It's the favorite part of my job. Writing the 5-page letter that says this is what you can do step by step based on what you got in there. And so it's all out.
Now, are there new fees for that?
Fees-
Is that included in the original
No,
cost, attorney cost?
No.
So it has more rear end cost.
you got rear end costs.
But that's the 500 admin that you said.
I don't, oh, you mean like an annual update
These-
fee? Oh, I see. Yeah, initially, yeah.
That was
Typically,
in your
that's,
initial budget.
yeah.
But is there an annual fee to maintain a trust? That's a great question.
You know, some attorneys do. Some attorneys will say, look, you gotta come in every 3 or 4 years. Let's meet, go through it, make sure everything's the way you want it, make sure everything that should be in it is in it. I don't do that with all my clients. I have maybe a handful of clients who kind of do that. But for the most part, I don't. I just tell clients, look, pull this thing out every 3 or 4 years, make sure it still fits what you want it to do. Come see me if you have any questions. It's always good every 5 or 6 years, I think, to get it reviewed, but you're gonna pay to have it reviewed. There's a couple of attorneys in town that do like it's like a,
Review.
yeah, maintenance fee thing. It's like $800 or something. And you automatically meet with them every 5 years or 10 years, whatever it is. I figure if my clients want to do that and they want to pay me more money, they'll call me. I feel like I don't know, it just feels a little. But
Now, what if somebody doesn't want to sell a property? How do lenders cooperate with new?
yeah, they don't, they don't, I mean, it's, you know, yeah, if a couple of the kids want to hang on to the property, it's got a mortgage on it. What they typically do if they want to hang on to it is they fly under the radar. I don't like that because there's risk, you know, if they ever call a note or what have you. Most of the lenders, most lenders, as long as they're getting their monthly payment, they don't care. They don't go, rarely do they check and see, oh, did this client die? Is the note now due? Because if you die, they can accelerate the balance of the note. It becomes due in full. And so if a couple of your heirs are going to inherit that property and they want to keep that mortgage in place, whether because it's a lower interest rate or they know they couldn't qualify, there's just a lot of issues with that. I mean, the biggest issue I see is, let's say that lender decides we're going to call the note. They call the note, the real estate market's crashed, and then there's a deficiency judgment when they foreclose on the property, and then they're looking to the trustee and then the other heirs to satisfy that deficiency judgment. So there's a lot of risk. If the market's good, there's not much risk. But as we saw in 07, 08, we had a lot of this where, yeah, we've got deficiency judgments on foreclosures, and that's the worst thing you could have with a trust or an estate that's been closed 2 or 3 years. You know, everybody's got their money, they've already spent it or what have you. And then they're looking to the trustee, the kid you trusted to get this thing done, and they're gonna come after that person to satisfy that deficiency judgment. Possibly. So,
Just make sure I'm clear on that then. So the way I got it set up is our kids split the property, they each take their own property, they become the owner in their own individual LLCs
Okay.
that have the mortgage on the property.
mhm.
They can have.
The LLC, if the loan is in the LLC's name, you might be okay. You're gonna wanna look at that loan doc, because a lot of times they'll have tucked in there that if any of the members die, they could call it, you know, let's say you and your spouse are the members right now, there may be something in there that says if the majority of the members die, that we can accelerate this note.
Can I do something like make the kids a 1% member of that LLC and then, so they're on.
Yeah, I don't know if that'll matter. You're gonna have to look at those loan docs. Yeah,
Thank you.
yeah, sure. Those loans are written in such a way that the banks are protected inside out, upside down. Yeah, it's.
So usually a sale is forced on death unless a trustee or an executor takes a risk and just keeps making the
If
payment.
there's a loan. Sometimes you'll set up your estate plan in such a way that, look, when I die, I want all the loans paid off. Take it out of this pile of money, pay everything off, distribute these specific assets to individuals. That works great. Although most people don't have that type of liquidity, I guess, you know, maybe we're gonna sell these two properties to pay off the loan and then distribute this out. But yeah, mortgages make it tough. Secured debt makes it hard.
What about taxes for the trust? So say your trust is generating income from all these properties.
Yeah.
You pay taxes an individual entity, does that pass through?
It's a flow. When you're alive and it's revocable, it's as if it doesn't exist from the IRS's standpoint for tax. When you die, if the trust generates income during that period of time, you know, that you pass away and the assets ultimately get distributed out or sold, normally that income gets passed through as well. But that trust or the estate does become a taxpayer the day you die. So the way to look at it is you're the taxpayer up until date of death. From that day forward, your estate or your trust is a taxpayer. It's kind of like an LLC where the income gets kicked out to everybody. You know, your beneficiaries or heirs get a K-1 for that year. Here's the income that's allocated to you based on what the estate income was or the trust income.
That's different for an irrevocable trust that gets its taxpayer.
Yeah, yeah. A lot of the irrevocable trusts are kind of like a flow through though. You can set them up to where the grantor, the person putting their stuff in it, for tax purposes is still the taxpayer on the trust. But we don't want to go down, I don't think. We're good. It's not that fun. Yeah.
Helen, if you put your kid on the title of the property, you have to wait well, the kids still have to step out of business or you don't know.
The law right now is if you retain a life estate and a remainder to your child, you should get a step up. I will say, you will get a step up under today's law. I wouldn't rely on putting kids on deeds though. Bad things can happen. Number one, how do you change it ever? So let's say that child ends up having creditor issues, bad marriage, whatever it is. With your will or your trust, it's easy. You go see your attorney and say, I got to do something to protect this. And they edit that. With the deed, unless they cooperate and they're willing to say, okay, yeah, I don't want that, mom, you know, forget it. You're stuck. And some people will do that to get around probate. You know, people will put other, you know, kids on deeds and all that stuff. It's high risk.
Creditors too, right?
Yeah. Yeah. If that kid has a creditor against them, as soon as they get that, they're going to come after it.
Accident or whatever.
Yeah. Anything. It's just not flexible. And if the deed's not worded exactly right, they may not get the step up. So you just have to be careful. And it still may require a probate. The title company may still require, even though you got death certificate and all that, they may want an executor appointed. So it doesn't always work.
On the death of the trustor, and the trustees do nothing with income generated there, but you decide they don't do anything.
Yeah.
So it continues to provide income. So that trust is still alive,
Okay.
and it'll stay alive until when?
Yeah. If nobody does anything.
Other than receive the income.
Yeah. Well, I guess it could go on and on and on. Legally, it's not supposed to. Normally, I just never see that because inevitably somebody wants their money now. You can set it up though. I mean, you can do this all day long and you can say, when I die, I want everything to stay in this trust. And I want it to generate income and I want it to go to my kids or whoever. They can't sell this stuff. I don't want them cashing it out. I want to provide an income stream for them the rest of their life. You can do that. There's different ways to do that. You can have, in Idaho, we can have, we call them legacy trusts that go from generation to generation. If you want to provide for your grandkids, your great grandkids, all of that, you can do that. There used to be rules that cut these trusts off after a certain period of time. In Idaho, we don't have that anymore. you can have it go on forever.
Specifically for generation skipping trust?
Yeah.
Or just in general?
Yeah, so what he's talking about is, what the IRS does is, I guess they're smart. What they want to do is they figure, well, if you're really wealthy, you give all your assets to your kids, we're gonna get an estate tax when you give it to your kids, then when your kids die, they're gonna be wealthy, we're gonna get another estate tax, and on and on and on. So what the IRS does, what people used to try to do is say, okay, I'm gonna skip that generation, give a bunch of stuff to my grandkids, or I'm gonna give stuff to great grandkids and all that to avoid that. We now have what they call a generation skipping transfer tax, and that's kind of what, can't do it anymore, but you do have that 14 million or whatever it is, you can use all of that to get around that. But if you try to use more than that, then there's this generation skipping transfer tax, and that's 3 hours of material that you don't. That's a good question. Yeah. Anything else, or?
It sounds like you really prefer a trust and the costs are similar at the end of the day and you find it to be cleaner.
I think it depends on several, I think, number one, it kind of, this is gonna sound bad maybe, but in part, it depends on your age. My clients in their 30s and 40s, I like the will, and I like trust built into the will for kids, because what they're really trying to protect against is if we died unexpectedly, and we've got kids that are under 20 or 30 years of age, or we have kids under 18 and we want to make it sure we have this person as a guardian for them going forward, I think the wills work fine. The reason I say that is people in their 30s, 40s, if I help them get the trust funded, they're never going to look at it again. And they are going to buy another house, and they're going to buy another house after that. They're going to buy that, and they're going to change banks, and they're never going to buy that new property in the name of the trust. Or I'd say there's about a 10% chance. If they're the most mature 30-year-old client I ever had, and they love going to the bank and moving stuff into the trust, it'll work fine. If you're in your 60s or 70s, 80s, it's a little easier. You're kind of, when you're 85 years old, maybe you're not buying and selling real estate quite as frequently as you were when you're 40 or 50. I don't know. This group's looking at me like, stop. But for most of my clients, that's kind of, my clients that are 90, they can't wait to go to the bank and spend an hour there and get stuff transferred around. You know, it's something to do. But my clients in their 30s, they don't want to do that. So I think it depends on a lot of factors. Age is a big factor for it, because when you're 35, 40, you got stuff going on. You got kids, you got soccer, whatever. And it's just not something you can think about again. So I think the wills work fine for younger couples. In fact, I prefer it because I know what's coming, and that is if they died unexpectedly and we set up a trust, we're going to do a probate and a trust administration. I just know that's what's going to.
Is it costly to add something to the trust after it's been created?
Like an asset.
Yeah, say you bought another house, it's like, let's throw that.
I think when you go to the title company, you tell them I want this in the trust, and you call your attorney and say, hey, remind me how to title this. A lot of what I do when we set up a trust, I send them a letter saying, this is the designation to use if you buy another piece of property. You know, so it's all there if you want to track down that letter, or just call whoever set it up. Or if you don't do it, yeah, if you forget, it's been 5 years, like, oh crap, that's in my name, and you get it to the trust, you can go to the title company, they'll do a quick claim deed for you, or your attorney will do one for you. Okay.
We're all processing, right?
I know it's a lot, just go see your lawyer and go through it. Yeah, he or she will be happy to see you. They'll be happy to help you, and they'll tell you what it's gonna cost. All that stuff. I mean, the cost is a factor, whether to do a will or a trust, and I think the first thing I said was the probate process here isn't near as cumbersome or difficult as it is in Boston. We still have really good access to the courts here, the probate court. Like I said, 3 to 5 business days, and I usually have an executor appointed. So
You have like a template or something that you would plan to fill out to kind of outlining what they're.
Yeah, so what I normally do is have them fill that out. They come in, we meet. We'll go through all of this and you just decide, okay, which route do I want to go? I can tell you, this is what it'll cost. This is how much of a hassle it's gonna be for you or not. It may be clean, it may be easy. I mean, if your estate's as easy as you have a house, you have a couple bank accounts, you got your investment account, and you really want to make it as easy as humanly possible for your kids, getting that trust set up is pretty easy, getting it funded is pretty easy. If you're dealing with LLCs and operating agreements and all this other stuff, it's just a little more complicated. I mean, yeah, it is, as you acquire assets and you do all of this, life gets a little tougher, you know? You're making more money, but you have more stuff to deal with, you know, that's how it is. And the estate planning is kind of the same way. All right.
All right, well,
thanks.
don't go anywhere.
Okay.
Oh, I mean, thank you.
Thanks for getting me over my fear of the, PowerPoint.
You did great.
Look at all those fancy, what do they call
Bullets.
it? Yeah. I thought I at least feedback.
I wasn't sure if it was harder to read on mine.
No, that was
so-
on me. Yeah.
Okay, well. Okay,
Oh, you do want.
yeah, we're gonna do recap, so. Yeah.
See it all
Put your name on it, right?
You guys should all leave. Who wants to hear this twice?
And I don't know, you'll have to correct me because I took notes,
Okay.
but this is like way complex for me.
Okay.
Okay, then. AVID Investors, thank you for being here. Todd, Winegar, thank you so much for teaching us about trusts and whether we should trust. This is what I heard today. I heard that one of the primary reasons to use a trust is to avoid probate and to centralize and clarify where all the assets go when one dies. And that it's an efficient way for an LLC interest to be dispersed, but review your operating agreement first, because there can be some hurdles. And maybe it's 2 to 5K plus 500 admin, so it's not insanely expensive everywhere you go. Wills, on the other hand, also are a way to clarify where assets go when you die. And when you use a will, you go through probate. And some people treat probate like it's the end of the world. But in Idaho, we're fortunate. It's a lot easier than it is in California. It's fast, it's inexpensive. And at the end of the day, the cost ends up being probably similar to that of the cost of a trust. You just pay a little bit to get it done and then more on the tail end.
Yeah.
Okay. And your executor doesn't have their power until they go through a court appointment, but again, it's a few days, no big deal. Your beneficiary or POD pay on death is still relevant in a will, whereas a trust wraps it all up into one.
Yeah, you can still do a POD with the trust, but if you're gonna go to the trouble of doing the trust, the POD, the idea behind it is to avoid probate of that asset. I like the idea of just using the trust.
But beneficiaries and PODs also avoid probate. One of the more obsolete benefits to a trust is avoiding inheritance tax because of the higher exemptions that currently exist, and that can change. 7 million, it might be at some point in a couple years, or 14 million for a married couple. But whichever way you go, all of your assets or your heirs get a step up in basis on death. So whether it's will or trust, revocable or irrevocable, your beneficiary or heirs get that step up in basis.
Irrevocable, no.
Okay. Okay. And the step up in basis means you've avoided capital gains taxes, or your heirs have. They get the full value of your estate. A trust is not, and nor a will, neither are a liability protection. Insurance is your best bet there when we're talking about rental properties. So high liability insurance.
And the LLC.
One of the most important things about your trust or your will is who you're putting in the position to deal with things for you when you die, especially with a will, or for both?
Both.
For both. Or when you're incapacitated, the part that we don't really want to think about, if you're still alive, who's in power. And so a trust can define that as can a will.
Well, so with the will, you have a power of attorney, a durable power of attorney, which is just another document. So whether you go a will or a trust, you're gonna avoid somebody that will do the same thing.
Okay.
Yep.
So that's an important detail when factoring in either of these decisions. The main goal, though, would be to avoid having to do both. So if you're going to do a trust, you want to do it right. And if you're 30, you're going to do it wrong because 30. So try to pick one and stick with it and get the assets into the trust if you're using a trust. And don't worry about probate in Idaho. And either way, you probably want to consult with someone as smart and humorous
Mhm.
as Todd here.
Yeah, hopefully, yeah. Well done.
Thank
That
you,
was
Todd.
great.
Thank you,
Yeah.
Avid Investors.